Gareth Peirce is a world-renowned solicitor and human rights activist. She has worked on some of the highest-profile cases involving allegations of human rights violations. She has represented those 5 Sikh activists who had their homes raided in September 2018 in relation to Jagtar Singh Johal. She is now representing the 3 UK Sikh activists facing extradition to India.
Can you hear me?
Yes.
Good. In a number of ways, the extradition process involving an Indian request for 3 British men to be taken to India to put on trial, in a way it presents a different side of exactly the same coin. Understanding the context. The context is the fragility of the right to protest and the right to articulate rights, and the unrestricted exercise of a powerful state to go after those it elects to go after. And the shocking realization for people on the receiving end, or people they know who are on the receiving end in this country, is that it's in an internationally cooperative legal process that this is taking place. And so the reach and power of the Indian state in relation to asking the exercise by the UK of its treaty obligations is bringing everything together in a court in this country that we have been hearing about today. Is that internationally accessible power for a state exploited? Yes. Is it exercised for political reasons? Yes. Are there barriers to its being progressed to successful conclusion, to men being transferred? Yes, there are barriers, and they are in large part embedded in the same treaties that allow for the request to be made. Central to the challenge to extradition is that it is not detached from the dynamics of real life and the progression of the shocking things we hear about today, in no way detached from it. Integral to the process of challenge is the political motivation of the requesting state. Are there barriers? Yes. Barriers that will prevent extradition if it's established that it's a politically motivated request, if it's by reason of the religion or the political opinion of the people who are requested. Would they be prejudiced at trial? If the answer is yes. Would they be ill-treated if they were in prison or in danger in India? If the answer is yes. If they will be prejudiced in their ability to have a fair trial, the answer is yes. All of that is a bar to extradition, and it could not take place. And the UK itself is bound by the European Convention on Human Rights. And so if from time to time, as can happen, extradition challenges fail within the UK, the European Court of Human Rights will stop an extradition. And the country it is stopping is, in that case, not India, but the UK, prevented from extradition to a country if it's violating those basic rights. So the context is inappropriately in the middle of London in a small court, perhaps investigating history, practices, recent practices of the Indian state, in particular towards members of the community in India. All of that behaviour is demanded within the extradition process to be investigated and brought to the attention of the court in evidence. Everything we have heard today, I and my colleague who have been listening with enormous interest, everything we have learned today is of relevance to the extradition hearing. As was just said, the judge hearing the cases was first before her, commented on the strength of the case and granted the 3 men bail. but every extradition case is a major challenge. The presumption is that the request is made in good faith by a state which is guaranteeing rights in the same way as the Treaty of Bruges. There's a long way to go, but anyone who can suggest anything that assists us, we are wanting to transfer our education into the court so the court will prevent the extradition. Thank you very much for asking us to participate today.